can be called by a more fancy name, Grundnorms or bedrock principles that are so Jus Cogens norms that are so undeniable, they're so inalienable that no jurisdiction could write law against them. So, for example, a precept against genocide might rise to that level. And then fourthly, judicial decisions and scholarly writings. But here, where we come, I think everybody in the audience here is coming from a common law jurisdiction where we rely on precedent. And so we look at judicial decisions as having a precedential value. That's not necessarily the case in international law. Different jurisdictions may not be bound by one or another court's rulings. But they can, in fact, be very, very influential when it comes to deciding how the law evolves. There's also so-called soft law, which are non-binding laws that, non-binding norms, excuse me, that influence state behavior and the increasing role of international organizations in shaping international legal norms. And here you have organizations like the UN coming into play with its special procedures, with its treaty bodies. I'm coming to you today actually directly from the Convention on the Status of Women Commission, and can see fully well the ways in which the law is and is not evolving with regards to gender parity. I'm very happy to delve into each of these, but I just wanted to give a quick overview. I think the main reason that I was asked here today is because the two preeminent international courts and tribunals, although there are multiple international courts and tribunals, are busier than they ever have been before and are more in the news than they ever have been before. And likewise, are possibly facing more blowback and more challenges than they ever have in their history. So heretofore, the International Court of Justice and the International Criminal Court have each had separate but complementary jurisdictions. And the International Court of Justice has mostly avoided the personal attacks of states, although it is an organ of states. And the International Criminal Court has different jurisdiction, which I'll get to in a moment, and has lately been experiencing, as you will have seen in the news, probably why we're here, immense pushback from several states. So perhaps, and I would like to see hands raised if there are any questions of clarification. I know we're going to get to a rich discussion period afterwards, but if anything I say is unclear or if you would like further elucidation, please just let me know. So let's just start out with the ICJ and the ICC. And I will, over the course probably of my remarks, touch on other international courts and regional courts and tribunals. So the ICJ has its origins in the UN Charter and is fundamentally the preeminent organ for the pacific resolution of disputes among states. So the means by which states don't go to war. This is embedded into the Charter, and it's embedded into the ICJ's general principles and jurisprudence subsequently. So the ICJ hears disputes one of four ways. They can be distilled a little bit more succinctly, probably into disputes between states and advisory opinions. But I'm going to go a little bit further because I know this is an advanced audience. The disputes between states can come up in one of three ways. They can come up because the issue at dispute is mentioned in a treaty, in what we call a compromissory clause. They can come up because the states in question have exceptionally indicated that they will take this matter to court before the ICJ. And they can come up in a third way between states. And that is when a state deposits a declaration accepting the compulsory jurisdiction of the International Court of Justice over contentious disputes. So, what that means, that's a very long-winded way of saying, is that the state in question has the faith in the ICJ to answer any and all questions that it might have with other states. It's an immensely powerful tool for several reasons. It's powerful because it shows that the state in question that has made that declaration has faith in the rule of law. It's powerful because the state in question can use the ICJ even outside treaty law, which can be somewhat confining in terms of its subject matter jurisdiction. And it's powerful because it really does further the message and the signal and the aspiration of the UN Charter that this was going to be the court to settle all disputes between states. So far, only 74 of the 193 UN member states have accepted such compulsory jurisdiction. And my organization, along with several like-minded organizations, currently has a campaign called Legal Alternatives to War, Law Not War, which was the maxim of the late Ben Ferencz, the last living prosecutor at Nuremberg, who was a member of my organization's National Advisory Council until his death last year, or I guess 2023. Now we're in 2025. And that this was the hope for the end of war. So that is the ICJ's jurisdiction. And currently, as I mentioned, it is busier than ever before. The ICJ is considered approximately 125 cases. It's moving every day. Since it was brought into being in 1945 and heard its first suit in 1947, or had its first decision in 1947, which was a matter of international humanitarian law or the law of war, the Corfu Channel case, where Albania and the UK were deciding whether or not the subterranean planting of missiles likely to set off on seagoing fare was a war crime. And the ICJ decided that it was, in fact, something for which one of the states was liable, that the UK was liable for planting these subterranean missiles. The so maybe I'll just stop there if there are any questions about the ICJ. I'll also point out that while it's heard approximately 125, as mentioned, cases since its inception establishment, it's currently seized approximately 24. And if you look at that in, that's kind of a large ratio that it's currently contemplating. That is quite a high workload for a court that has not effectively been granted more resources over time, nor had its working modalities change. One of the interesting aspects of the ICJ is that all 15 of its judges have to sit en banc, so all of them in one place, whenever a single decision is reached, including early procedural matters. And so this can be it can cause quite a backload or perhaps a bottleneck at times. At this time, the court, as of several days ago, the court may have been seized of its fifth case of genocide contemporaneously. There were four cases, are four cases that are working their way through the ICJ system, and the law that the ICJ applies is, in this case, the Treaty on Genocide. And then on March 6th, there was a deposition by Sudan against the United Arab Emirates, also under the Genocide Treaty. And I don't believe the court has yet ruled whether or not that will move past the procedural merits stage. I'll say at this point that I'm going to put some guardrails on the conversation, that I'm not going to talk about any cases on their merits, either before the ICJ or the ICC. I really want to be here as a resource to understand how these courts work, how activists and civil society can access them, but not to opine on any specific cases. Um, we can touch on those as they come up. With that being said, the ICJ has also expanded in diversity of what it is willing and able to hear. And here we have the last way in which a case will reach the court, which is the request for an advisory opinion. And we have right now this phenomenal instance of a request for an advisory opinion on the obligation of states with regards to climate change. And this was the first time in history that a case had been referred, an advisory opinion had been referred to the ICJ unanimously by the UN General Assembly. So the way that it works when an advisory opinion is requested is that the UN General Assembly makes it. And normally there are a few requesting states or a consensus. Some folks sit out. Here it was unanimous. Yes, there were abstentions. But it was also the first time, well, it made records in terms of the number of interventions by states and by non-state actors before the ICJ during the oral hearings, which I was privileged to be around in The Hague over 2 weeks in late December of last year. And so during those hearings, states first take the floor, and I don't know the penultimate record of who got next best, but nobody was close to over 100 states intervening in a case in an advisory opinion proceeding, as with this advisory opinion on climate change. Moreover, the role of intergovernmental organizations and non-governmental organizations took on a profound role over these not only 2 weeks, but prior and subsequently through deposition of Amici Curiae, Friends of the Court briefs, and subsequent expert analysis. But the real part of this advisory opinion case, and if I could say anything about the role of international law when it comes to activism, is in its true germ and true origin. The way that this case came about was not by some erudite lawyer on high thinking that this would be a great test case or a white shoe firm. This was young people from the Pacific Islands who mobilized. And I want to shout out here to the World Youth for Climate Justice. And when I get a chance, I'll put some links in the chat maybe, or we can send those later, who mobilized to their governments facing the existential threat of their homeland disappearing. And so without any legal background in most of their cases, some cases high school students, and from in many instances, those without regular access to wonderful educational resources, they banded together and thought up a plan of step A to B to C to D to Z. And we are going to advocate to our individual governments in the Pacific Islands. The governments then take this to like-minded states in New York and Geneva and elsewhere. They then bring this to the UN General Assembly and request an advisory opinion. And lo and behold, you have this remote court in The Hague that is seen as so disconnected, I guess, by many from our lived experience, answering, hopefully, the questions and maybe even the prayers of young people in Pacific Island nations. So that is what I will say at the moment about the use of the International Court of Justice as a tool for activism. I will say that it can be used in a variety of other ways with some of the caveats that I've mentioned about bandwidth, etc. And that it is a court that is seized of questions between states. So advisory opinions or contentious disputes between states, not a human rights court. Human rights court would be a court like the European Court of Human Rights or the Inter-American Court of Human Rights, or to some extent, the African Court of Human and People's Rights, where they hear disputes by individual citizens against their government. That is not the ICJ's jurisdiction. And now we're going to come to the ICC, the International.
Rebecca,
Yes.
can I call on myself and ask you a question?
Yeah, absolutely. Please do. Thank you.
Sure. Two things, actually, too. First, you mentioned there were interventions around the climate. Now, is it an advisory? The climate thing.
Advisory opinion. Yeah.
Okay. What is an intervention, good or bad? I don't understand. In my mind, it's like people standing up and yelling.
No. It's well, people do stand up and yell too. But and that also and these things can be mutually supportive. There were tons of demonstrations around the Peace Palace, where the International Court of Justice is housed while these were going on. And yeah, raising your voice is all very well, but there is actually a formal process of intervening where third parties can make depositions to the court. And so here you need to be granted the right to do so by the ICJ. And that would be, for example, if you're a scientific expert, a learned scholar on environmental issues, if you are a regional body with an interest in the issue. So we have many regional bodies from the Persian Gulf to SADC, from Southern African Development Community, to the Inter-American system, say that they have an interest and they want to intervene. And so that's the way that those those are the types of bodies that you see making interventions, and they have to request leave from the court to do so in a formal as a formal third-party submission. But of course, anybody can stand up and shout outside the Peace Palace.
So I'm still not like, was it a good thing? Were people intervening in support of the climate thing?
Yeah, I believe that of the 100 state parties that intervene, the vast majority of them were wholeheartedly in support of climate justice. And several of them probably had some reservations, and we know who those are. But I think it is a good thing that you see more states participating and more third-party actors participating before the court, because it gives them, and I also point out that before the court, I think before oral arguments, the court, in a sort of sui generis moment, had its own panel of experts convened. And there was some thought about whether that exceeded the boundaries of the court's jurisdiction. So I won't go too far into that, but I have to believe that it's generally positive that you are hearing more expert opinion, that you are hearing more opinion from a more diverse array of sources, and that more I won't say individuals, but more stakeholders are availing themselves of the court's justice.
Thank you. I got it.
Um, so with that, maybe I will move on to the International Criminal Court. I didn't have a really great segue here, other than the fact that they are commonly confused and both of them are busier than ever before, and in some cases seized of complementary but not duplicative subject matter. So the ICC, and I apologize if I'm patronizing anybody in the audience, is a court that is based on individual criminal responsibility for crimes under its jurisdiction. Those are genocide, crimes against humanity, war crimes, and the crime of aggression. Crime of aggression with a little asterisk because there are some lacunae yet to be filled in. And so the International Criminal Court, as opposed to the ICJ, which was envisioned in the foundational document, the UN Charter, is a much later invention. Maybe I always shudder because there's sometimes people in the audience who were actually at the Rome negotiations in 1998 that brought the court into being and that know this far better than I. But where the ICJ is the principal judicial body of the United Nations system, the ICC, which came into being after the requisite number of, excuse me, of accessions in 2002, was a innovation that many of us have seen in our lifetime was brought about by civil society activism. So again, when you give me the prompt of what activists can do vis-a-vis international law, this court would not exist full stop, but for civil society and activism. So even prior to the 1945 UN Charter, going back to the Hague Peace Conferences beginning in 1899, there had been the thought that there must be a court to prosecute the worst criminals, the worst individuals that guilty of crimes that shock the conscience of humanity. And then after World War II, of course, this gained more momentum and gained more steam with regards to legal communities. But yet, over the intervening decades, and I have written on this and I can talk about the reasons why, lapsed in the face of kind of the geopolitics of the time. Up until we had this moment in the 1990s, where I really credit the Coalition for the International Criminal Court, in particular led by Bill Pace, who is a mentor of mine and a procedure in sort of the role that I have now, for galvanizing about 20 some odd civil society groups in the mid 90s and talking intensively about what an international criminal court would look like, and then making the necessary advocacy towards states. And I honestly, having just come from this UN conference, don't know what that would look like today. I will also talk about some of the new courts and tribunals that I'm contemplating, where I have to think about what it would look like today. But what it looked like then was a lot of appealing to individual states, a lot of appealing to international law, and a lot of going back to what the core principles of the United Nations and a foundational global cooperation system were. This had come off of the ad hoc tribunals, as they're called, the tribunals for the International Criminal Tribunal for Yugoslavia and the International Criminal Tribunal for Rwanda, which themselves borrowed somewhat from Nuremberg, but began to write their own case law, began to write their own modus operandi and jurisprudence. Um, what was difficult, one of the things that was difficult about the ICTY and ICTR is that there was no notion that there would be a permanent court that would be able to handle similar matters. These were very much, these were specific to the cases in question. And there's an argument to be made about specified courts and tribunals, but the thought was that there are atrocities being committed all over the globe, and what we see here in Rwanda and what we see here in the former Yugoslavia is being perpetuated at a large scale that we have no other judicial mechanism to deal with. So there we had the birth of the International Criminal Court. As I mentioned, it has those 4 crimes under its jurisdiction. Now, I really want to stress that the ICC is founded on a principle of complementarity and cooperation. So complementarity means, and I don't necessarily like this wording, but it's the most agreed upon wording. When a state is unwilling or unable to prosecute, only then can the ICC step in with jurisdiction. And cooperation, like the ICJ, the ICC does not have a police force, does not have an enforcement arm for implementation. Here we've seen very recently a couple of egregious instances of non-cooperation with arrest warrants by states parties to the ICC. The ICC currently has 125 states parties, and its jurisdiction is limited to crimes committed on the territory of those states parties or by persons of those states parties. And sometimes you have one or the other. And here is where we have contentious disputes. The United States is not a member of the ICC. We are a signatory to the Rome Statute, the foundational treaty of the International Criminal Court. In fact, my mentor, Ambassador David Sheffer, who was the first ambassador at large, at that time styled ambassador at large for war crimes of the United States, now styled ambassador at large for global criminal justice, or at least it will be until this administration decides otherwise. He inked his name to the Rome Statute literally in the 11th hour before it was going to close for signature at the UN premises. And the reason for the United States being late to the game, even though we were really integral in all of the negotiations leading up to the Rome Statute, and I can give some more resources here, was worry over jurisdiction over American persons. And in the estimation, and I'm quoting him, so of Ambassador Sheffer, that issue was solved. And when he was serving under President Clinton and put his name to the statute, the idea was that it would only be a few years before we would ratify once the issue of individual criminal responsibility over U.S. persons was resolved. And like it or not, I don't like it. The American Service Members Protection Act, an act of Congress that aimed to further shield U.S. persons, U.S. service members in particular, from the court's jurisdiction, did just that. And so Ambassador Sheffer has recently written in a journal that I publish about the United States should now join the Rome Statute. I don't think that's very likely under this administration, but just kind of trying to backtrack to the thinking at the time and rewind the wheels a little bit, how we got where we are. The United States also has been an incredible collaborator with the ICC while not being a state party. There are different ways in which one can support the International Criminal Court without being a member state. These include, for example, the fact that the first two individuals surrendered to the court's justice in The Hague were thanks to the cooperation of the United States. And one of them literally walked into the US Embassy and surrendered himself. Further, the United States has provided valuable assistance with regards to cyber attacks and intimidation that the court has suffered, especially in recent years. And lastly, there is an entity that I think is little known and less understood, perhaps, called the Trust Fund for Victims, which is separate and distinct from the judicial organs of the International Criminal Court. And that has a dual mandate for assistance and reparations for survivors and victims of the atrocities that the court contemplates. And there, any state, not only member states, can make contributions. And they can also make so-called earmarked contributions, whereas no state can make earmarked contributions to the ICC for judicial purposes. But for the purposes of helping victims, witnesses, survivors, at the trust fund level, a state can. And so, for example, you have states intervening and making massive donations for sexual and gender-based crimes. And the United States has been among those states that have done so, even while not being a party to the Rome Statute. Now we face what is, quite frankly, just an unfathomable moment of an attack on an independent and autonomous judicial institution. We've had a previous run through of what sanctions regimes would look like, but they were quite short-lived and not very that they didn't work their way through the legal system, so not very well litigated. That was in 2020, on September 2nd, 2020. I know the date well because it was the date that I became the co-convener of the Washington Working Group for the ICC and the date after my birthday. The previous Trump administration announced that it would administer sanctions against two individuals of the court, the then prosecutor, Madam Fatou Bensouda, and one of her senior staff members. And sanctions are a very important tool in the US and other states' foreign policy arsenals. They're usually used to target kleptocrats or war criminals, ironically, and separate them from their assets, freeze their funds, limit their travel availability, and the means by which they can interact with US or, if it was another state, that state's individuals. In 2020, there were only 4 months before the sanctions were mooted. The sanctions designation was mooted by the incoming administration of President Joseph Biden. And at that point, there were 2 court cases that were lodged in federal court in 2 different districts, one led by the ACLU, one led by the Open Society Justice Initiative, with my friends as named plaintiffs. They have slightly different merits, but one of the main claims in both of those cases that we're going to look at again is that while US individuals normally are not subject to sanctions, this is not always the case, but subsequent to sanctioning of certain Islamic charities. That tool has not really been used for U.S. persons. We can be held liable for very serious criminal and civil penalties if we are deemed to cooperate or materially aid and abet individuals under the U.S. sanctions regime. So here we have, over the course of the last, well, since 2023, mid-2023, looked at legislation potentially coming through Congress that would place sanctions upon the court. There was a bill called the Countering the Illegitimate Court Counteraction Act that passed in the previous Congress, the House, and then held up the Senate for Senate Foreign Relations Committee for about 6 or 7 months, and then was reintroduced as one of the earliest actions of the current House of Representatives and passed the House of Representatives by a significant margin again. And behind the scenes, many of us, and thank you to all the peace action folks who stood in solidarity and who are part of this, lobbied very hard so that it did not pass the Senate this time. And it was really by a hair's breadth that this sanctions legislation, which was just copy and paste from the previous Congress, did not pass by means of congressional action. But what did happen, I've likened it to the sword of Damocles. So we knew all this time that we were working against the congressional action, that there was likely going to be an executive order, and there was. And so the executive order currently places sanctions on the ICC, and there's a 60-day period from the day in February. I don't have it in front of me, about 3 weeks ago, when it was announced, where further designations can or may be made. About a week after the initial sanctions EO, the first designation was made against the prosecutor. No real surprise there, Mr. Karim Khan. And now we're in a posture, as we have been previously, of seeking strategic litigation for those folks who work with the court to support victims, support survivors, support peace and justice issues. And now we're also in a position where we are looking to protect ourselves, because with a significant amount left in this administration and no telling kind of who might be called up, I think many of us are feeling personally the pressure of what it means to cooperate with international judicial institutions at this time. I'm going to stop there on a somber note. I'm sorry. Hopefully I'll be able to give you some uplifting comments in the question and answer.
That's okay. Bringing us honest information is what we actually asked. Okay, please, folks, you can use a chat or put up your hand. And Diane, I'm gonna give you the ability to unmute. Did it work?
Yes, I hope so. Can you hear me?
Yes.
So I apologize if I missed your mentioning this. A lot of this is new information for me, but I'm interested with these courts in who serves on them, how they're selected, how many judges there are, how often they turn over, and anything about who these people are who are sitting in judgment. Thank you.
Thanks, Diane. That's a great question. Amy, can I maybe suggest that I take a couple questions at a time, and then I can come back to both? I won't miss anybody, I promise.
Sure, if that's what works for you. Moji, can you get your question in there quickly before she forgets?
Hi, Rebecca, and thanks, Amy. My question is, I'm a social scientist, and a cultural psychologist. To what extent do the pressures that are being put on the UN system as a whole, but specifically its tribunals, judicial tribunals, are pressures that are put specifically by Israel and also by the what I call the military-industrial complex to normalize an exceptionalism in the international law, to say the international law applies only to countries except the countries, like especially they don't apply to Israel and to the United States. To what extent this underlying motive is the the purpose for which general norms of international law and the rules-based system are being undermined. Sorry if I got too wordy.
Well, I'll take the first question, which is also probably um, more not quantitative, and there are easier answers, perhaps. So the International Court of Justice has 15 judges that are elected to 9-year terms, and the International Criminal Court has 18 judges also who serve 9-year terms. And the idea is that there is not they overlap in terms of their terms, so you're not having a full election at every time. And then the ICJ has a voting body that is elected in parallel to the United Nations General Assembly and the Security Council. And there are regional representation requirements there. States for Western countries, 3. I'm gonna do this. 3 for African countries, 2 for Eastern European, 3 for Asian, and 2 for Latin American. What there is not is any gender or other consideration. So there have been approximately 120, 125 judges. I don't have the number in front of me over the court's longevity. If anyone wants to guess how many of those have been women? 6. 6. And 2 of those have been Americans, interestingly. So when we talk about our antipathy as Americans to, or as the United States, as our government to international law, it's a far more nuanced, I think, conversation than that. And in fact, one of those Americans is currently serving, Sarah Cleveland, on the court. And one of those is outgoing president, the last president of the court, Joan Donahue. And there is a process elucidated for the ICJ on selecting judges based on merit, but that isn't completely articulated. It just lies in the foundational documents of the court. Conversely, the ICC, which was a more recent phenomenon, tried to correct some of these issues in its foundational treaty, in its foundational statute, having gender balance baked in, having the 18 versus 15, and having the fact that you would only have a pretrial chamber or a trial chamber, an appellate chamber of 6 composed at each time, so you didn't have to bring everybody to the table. And in fact, some procedural decisions, minor ones, can be taken by a single judge. These things, which are evolving constructs. So those were notes that I think the ICC took from the ICJ, but are also still kind of evolving. Not kind of evolving, they are evolving. In an independent expert review of the International Criminal Court, the high moral caliber and qualifications that are elucidated in the Rome Statute, which are kind of complicated. There's a list A and list B. One is whether or not you have international law expertise, and whether or not the other is if you have criminal law expertise. And this was just what came out of the wood chipper with all the negotiations between states. But so what the independent expert review yielded was that some of the qualifications, like high moral caliber, weren't really fully articulated. And so civil society has played an important role here. Again, the way that activists can step up. And I commend particularly the Open Society Justice Initiative that said, okay, well, let's come up with a list of what the qualifications for judges should be, and let's vet them publicly. And anybody who does not want to come to civil society, to the Coalition for the International Criminal Court, and answer the questions or answer the questionnaire and then maybe participate in the public dialogue, well, they'll be noted. And that, I think, really has helped shape the way that the International Criminal Court is evolving over time. And, it's a work in progress. It's a human-made institution. Now, about selectivity and the potential politicization of the court. Of course, these are issues that have plagued the court since its inception. It's very interesting that, for the majority of the court's short lifespan, the allegations of selectivity and double standards and justice really resonated with the African continent. Why are there so many cases in Africa versus the rest of the world? And in fact, when you look at it, many of those, and I think when it comes out in the wash, most are either proprio moto, which means not proprio moto, which means the prosecutor went after them, but they are self-referrals. Or in two cases, Libya and Sudan, they're the only cases in which the UN Security Council referred a case for the court. Proprio moto has actually been more geographically diverse, where the prosecutor has used her or his volition to seek the court's approval to take a situation to the investigation phase before proceeding to a prosecution. And now you have that in a variety of jurisdictions. So we now have cases or situations, I'll say situations, in a wider geographic terrain. And yet the selective justice has not necessarily, that claim has not necessarily fallen into hindsight. With the situations that have earned ire from the United States, among others, in Afghanistan, situation in Palestine, I'm using that verbiage, that is the verbiage that the court uses, or situations in Ukraine, the situation in Myanmar, Bangladesh. You see Georgia, you do see the extent of the court's geographic diversification, but at the same time, with that comes fresh, and I'm not saying that these are unfounded, but fresh allegations or blowback against its the reasons for it bringing a or the reasons for a situation coming before it. And I want to again stress that there are multiple ways that a situation comes to the court. Only one of those is proprio moto, and that's not that frequent, but where the prosecutor asks for a case. That's, I think, what most people have in their minds when they think about the ICC, and they're not thinking about state referrals or self-referrals or UNSC, which has only been in those two cases. And I left off, of course, the Latin American continent, or Latin America, and the Caribbean and South America, where there have been, where currently the court is seized of situations in Colombia and Venezuela. I shouldn't have done that.
Okay, we have another question. Jesse, can you unmute?
Hi, question regarding whenever I hear heads of state for the United States speak, they always refer to the rules-based order as opposed to international order. What do you have to say about? I've heard, I have a basic understanding of the two ideas. That one is U.S. uses it as our heads of state uses synonymous with international law, and the other is it's whatever the United States thinks is the right thing to do for the United States and its allies.
I'm afraid I don't have a very good legal answer to that question because I think it is at the realm of rhetoric, and I think it is kind of in the eye of the beholder. When I speak as an international lawyer, I refer to international legal principles and the rules-based order that undergirds them. And while there shouldn't be picking and choosing, there is reservations within that order. There are perennial objectors. So I don't know that the semantics make so much of a difference as much as the compliance or the cooperation does. But maybe others will have better thoughts on that than I.
We are getting close to the end here, but I guess if anyone wants to, Rebecca is inviting if there's some other idea here. I don't see anyone. Okay, yeah, we are very close to needing to end anyway. So, wow, that was a lot of information. Thank you so much, Rebecca. This one, I'm really glad we are archiving because I know I'm going to have to go over it again. I'm sure some of you are more steeped in these terms and such, and that's great. We're so glad that we did this. Let me say a few things to wrap up the night. So if you do have anything, Rebecca, you want to put in the chat as far as places for people to follow up, go for it. Meanwhile, I did put nhpeaceaction.org/events in there. That's a way to keep up with us. I'll give you a quick overview of things we have coming up. Our Ceasefire Now vigils continue Wednesday, March 12th, 2 to 3 p.m. at Senator Shaheen's office in Dover. The following day, Thursday, March 13th, noon to 1, folks will be at City Plaza in Concord. And then next week, Wednesday, March 19th, 2 to 3, we'll be at Representative Pappas's Dover office. On Sunday, March 16th, 4 p.m., Countering Christian Nationalism hybrid event is happening. The first in a three-part series. It seeks to explain the origins, tenets, and impacts of Christian nationalism, particularly in the context of New Hampshire. On March 19th at 12 p.m. Eastern Time on Zoom, there's a webinar about women in conflict zones. It aims to shed light on the profound impacts of war on women and children and to discuss measures being taken to mitigate these efforts. We are co-sponsors of both of those, so they are on you can find them through our website or our Facebook page. Our next Monday Peace and Justice conversation will be the feminist path to peace, women's leadership in the movement for peace in Korea. That's going to be Women Cross DMZ speaking to us. I'm sure a lot of you know their amazing work. That's Monday, March 24th, 7 p.m. on Zoom. This series is free and open to everyone, but I'm dropping into the chat. And then, oh, no, it didn't work quite right. Well, here, I'll say it. nhpsection.org/donate. We love getting your support in many ways, and that includes financially. So with all of my wrap up done, just if folks can join me in a real visible thank you to Rebecca for taking this time to come and talk with us about a really complicated, big subject that hopefully this gave us another little piece to digest and go further with. Rebecca, did you want to say?
Thank you so much, Amy. I mean, it's been a pleasure. Well, I wish I could say it was an unadulterated pleasure to be here, but it is a privilege to be with you all and see other people committed and doing the good work. I will also just mention that the Washington Working Group for the ICC meets monthly. And I was just trying to look up, I think our next meeting will be on the last Thursday of March. And they went from being entirely local, small congregations of folks over lunch discussing the U.S. Congressional relationship with the International Criminal Court back in the early 2000s to now very hybrid, very unfortunately active congregations of a whole set of folks. So we would love to see some of you there if you are interested in these issues. And I put my email in the chat if you want to follow up. And sorry I didn't get to some of the questions. Likewise, would be happy to follow up.
Great, thank you so much. And we'll make sure I'm kind of pointing that out in the chat, giving people a minute to grab her information. And of course, you can write to us if we shut down before you get what you need. You can always follow up with New Hampshire Peace Action, and we will try to connect